9:29. We start at 9:30. Please ensure, listen to me carefully, please ensure that your cell phones are off. We don't want them to disturb the proceedings. Make sure that they are either off or on silent. Thank you.
Good morning, Mr. Law. Good morning, Ms. van der Heever. Good morning, Mr. Madlanga.
Good morning, Chairperson. Good morning, Commissioner.
Please pull the mics closer to you and switch both of them on.
Morning, Chair, and morning, Commissioners.
I greeted you and your mic was off. Good morning.
Good morning once again, Commissioner.
Thank you.
Thank you, Chair. Chair, Commissioners, you'll recall that Mr. Matala had been subpoenaed to appear on the 7th of July, 2026. And on that date, Mr. Matala's legal representative and I presented ourselves before you, and we had an engagement, the outcome of which was that Mr. Matala's appearance was postponed to the 15th of July. Today, and the commissioners issued a ruling in that regard and on some other aspects. Mr. Matala is present. We are back before you, and Mr. Matala's legal representatives would like to address you, Chair. The issue about which she is about to address you is contained in the folders that have been made available to you, but I will leave it to her to take the commissioners through the contents of that folder. Thank you.
Ms. van der Heever.
Good morning again, Chairperson, Commissioners. We have prepared for your benefit and in support of our application for a postponement, an affidavit that was duly deposed to by our client. Due to time constraints, however, we were only able to last night email an unsigned copy to my learned friend. The situation was that for a variety of reasons, this could not be done earlier. I would like to very briefly, if it's necessary, Chairperson, Commissioners, just take you through our reasoning as to why we respectfully submit that a postponement in this matter should be granted.
Is there a signed affidavit now?
There's indeed a signed. It was commissioned this morning, and we thank the commissions, my learned friend and her team, for assisting us with that. Even at, I think, at 10 o'clock, there was another endeavor made to get it signed at the prison. There were some arrangements, but it just came to no fruition.
I do see it in a small folder in front of me. I read from my laptop, and that was an unsigned version. Thank you, thank you.
Chairperson, in short, we set out the history of what's transpired vis-a-vis Mr. Matlala, when he was arrested, how the events surrounding him has unfolded. And the most important aspect thereof is the fact that he's due to commence with a trial on Monday. We believe that he's got the constitutional right to attend this trial and be regarded as innocent until proven guilty, together with the other constitutional rights that we've dealt with in this particular affidavit. We respectfully submit that for him to deal with some of the issues, which issues play a very big part in the up-and-coming trial that starts in 4 days, would violate his constitutional right to actually challenge the evidence. We've indicated to you, for instance, that both Witness C and Lieutenant General Nkomazi relied on a statement that was given to them by Mr. Matlala.
Before you get to that point, let me ask a general question. Is the submission that a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings?
May it please, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my
You
client...
see, I'm raising the point that that was a minority judgment to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder.
Yeah.
I did not say anything.
No, I think respectfully, what I've endeavored to show to you...
You know what we always say in the legal profession, both amongst legal practitioners and people presiding, that when counsel says respectfully, they actually mean the opposite.
I was told that many years ago by a good friend that presided over a trial where he said, that was the impression. But I
sorry for interrupting you. I'm sorry. Yes, please.
I fully understand.
Yes.
The point is that is the nearest that we could come to any authority on this point. And this issue to us was so important that we were going to try and see if we could actually deal with this matter, if necessary, elsewhere. Where we are right now, I respectfully submit, we don't have to go there.
Where is elsewhere? Is it a court application?
Yes. No, only the approach would have been to actually make, if the matter were to continue, to make the necessary full-blown legal argument and submissions to you, and then depending on your findings to take it on review. I'm honest, I've indicated that to my learned friend before too. It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty-bound to come and do at the commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc. And for that reason, we will, at the end, of course, also assist the Commission in finding the truth in this, what I respectfully say is a quagmire of facts that you have to deal with. That is the one issue.
Or may I, before you go to the next issue, a difficulty that I have, and that of course is subject to your response, is that this is raised, or this is being raised in a blanket fashion, is the suggestion that any and everything that Mr. Madlanga could ever say before this commission would be something that would be subject to the exercise of his Section 35 right? Is that what's being suggested? And that there is nothing whatsoever that he could ever say which would be unaffected by his Section 35 right? Is that what's being suggested?
That is not what I'm saying, and I think I've made that quite clear when I discussed with my learned friend. The difficulties that we find ourselves in at this point in time, and that was also the issue that prevented us from actually dealing with any affidavit beforehand, is that our client, and I was not party to that particular agreement, I only came in later, through a different legal representative with IDAC, the gentleman that's been named here was part of that, entered into to a 105A plea agreement. The magistrate then came back and found that the sentence wasn't just, and therefore gave all the parties time to go and reconsider. The issue that, that's when I got briefed to come back in, because there were very material and important issues that were not raised in the 105A that we believe would have materially influenced potentially the outcome of such an agreement. The only time that that matter could be dealt with, or the issues that was raised at that point, and if you bear with me, I have to choose my words carefully at this point because it's a very difficult situation, was when the magistrate finally made a ruling. So past Monday, that is a day ago, 2 days ago, he actually, in terms, I think it's 105 capital A 9B Roman 2, if I'm correct. He actually said, well, he asked the state, what is your contention? The state said, oh, we wish to continue. He asked us and we said, no, we assail from the agreement. What then happens in terms of the Criminal Procedure Act is that it's as if there was never any plea negotiations happened. The issue for me is, and this is where I want to answer your question, Chairperson, is we were not involved in those negotiations. We know what transpired and under what circumstances in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody's say-so say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client how that these are questions that you have to answer. You're compelled to answer them. You can't, let's say, invoke Section 35 rights. And as we sit here, Chairperson, we still can't give you an answer to that question because we still don't have that. So there is, of course, and that is the long and the short of it, there is answers that you can answer. But at this point, I can't come to you as an officer of the court in honesty and say to you, okay, this is my instructions. I need to, because of this quagmire of IDAC's involvement, be sure that what we say to you is truthful, because there's also the penalty of perjury, and of course there's a previous inconsistent statement that can be raised at any stage. So for that reason alone, I agree with you. There are issues, of course, you can never assail your compulsion to answer to those. But until such time as we can present to this Honourable Commission an affidavit that we satisfied contains is based on facts and where we can invoke that right correctly, I cannot even go as far as to say we don't know this person. For instance, I could have come to you now because I know from the list, Annexure A, we could give you a list and say we don't know these people. But for the rest, it's not in your interest that we present, in your, and I mean the Commission, the Royal you, interest that we present in piecemeal fashion answers to questions. The fact of the matter is that my client has been made out to be this mastermind by everybody. And we respectfully, from our interaction, say that there's a fallacy in that. And we intend to show...
Please tell me when you are done with responding to my question. So, before you move on to another point.
I've basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then ask you, does that mean there are no questions whatsoever that Mr. Madlanga could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level,
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing and I need to understand in those negotiations who, what and where. And without that, I cannot,
Are you talking negotiations relating to the plea deal?
Relating to the plea.
That's history now. I'm asking you about now. I'm asking you about now, please.
It's not history because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not committed to.
Is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir,
I'm asking you about the precedence.
Yes,
Which of the two processes must precede the other? So I understood you to be referring to the plea deal in the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end.
No.
That's something else altogether.
No, that's not what...
It has nothing to do with whether. Once the plea deal is dead and buried, must the commission process wait for the criminal process? So the earlier issue, the plea deal, its finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain to
All
you.
right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say,
no,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Madlanga is able to deal with before this commission. Now, you are talking about issues that, post the plea deal, may also fall under the Section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside. And let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner, or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying, I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of, on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket, even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to your next point.
No, I do understand you quite clearly. The only issues that my client can answer, Chairperson, at this point, that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please, the rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if I can.
I have not asked you that. You are trying to answer a question which I have not asked you. I have not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is, on those issues on which there is no question whatsoever, those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the Section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the Section 35 basket on those issues. And again, I repeat, this is a general question. On those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process? What would the basis of not doing so be?
The only basis would be that the evidence will then be presented piecemeal. I've said to you, Chairperson, and I stand by it. The only things that he can say to you at this point, I don't know A, B, C, D, and E. The rest of the issues we cannot deal with. And I, with the greatest of respect, do not think it would be in your interest for him to sit here and say, I don't know this person, I don't know this person, I don't know this person. That's the only issues that we can form common cause on that he can at this point answer. We are trying to come to the Commission and answer what we can. The problem is, and I'm sorry to repeat myself, I can only do so if I know what he can answer is shown to me in black and white. I am trying to ensure that my client comes to this Commission and gives evidence to you that is to your benefit, i.e. the work of the Commission. And not for him to be to answer things that we as legal officers, and you've been in our position before, you can never allow a client to go on oath if you as the lawyer are not sure what he said there is right. I will not perform my duty as an officer of the court if I allow that. And for that reason, right now, I can claim privilege clearly on certain issues. I can say, this is my Section 35 issues. The others, I say to you, I can't at this stage because I don't know what's going on in the background. So it might even be, once I've got the documents that I think is necessary for me to decide it, that we can move on that. But right now, we can't. And I respectfully submit that based on the remainder of the issues that we've put here, that this Commission should allow him the opportunity to finish the trial. And more so...
Again, please tell me when you are done
yes,
responding to my question.
And then the last thing is, I think the thing that concerns me the most is, and we've taken the liberty of sharing a privileged document with you pertaining to the opinion. The one
I think that's something else then. Can I come in? Yeah.
And when that is, for me personally, is very concerning at this point in time.
When you referred to a piecemeal hearing, this is just for clarity, does that mean you are going back on the earlier acceptance of what I posited to you, which was, is it something that can be done for this Commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like, it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. And I do not quite get it why Mr. Madlanga could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. He knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
But Chairperson, the situation is
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
no, it is different because when people enter into plea deals, there's certain consensus reached and it goes, it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often, there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the Commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying. But if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Madlanga knows. And that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoke my right here and there and wherever, when I know in law the situation is that is a life process and he cannot invoke that right at that point in time. The facts, with the greatest of respect, you say that you have to answer facts, but facts have context and facts have background. You might see something as a fact because you've got a General Mkonazi that comes and says, oh, he said A, B, and C. I come back and I can't exercise that constitutional right before you and say, whatever General Mkonazi said, he got out because the client was forced unlawfully and unconstitutionally to answer questions. He was not allowed, for instance, to have access to a lawyer. He was questioned for over 6 hours without food, etc. That surely influences that fact. Then it becomes no more a fact that we can rely on. It becomes a fact. And we know you are dealing with it as a fact because it's part of the process here. But it's a fact that was obtained unlawfully. And we have the right to make sure that you also know down the line that the facts that you rely on, General Mkonazi, for instance, say so, are not lawfully obtained facts. I can't come here and I'll say, please call so-and-so, put him in the box so I can challenge him as to how these facts that everybody now relies on were obtained. I can do that, however, because it's part and parcel of my trial that's starting on Monday.
It's exactly because there are those allegations, not only by General Mkonazi, but by many others, that the commission wants to hear from Mr. Matlala, get his and underline his facts. You emphasize facts coming from General Mkwanazi, and I add him and others. You emphasize those facts. What the commission is interested now is facts from Mr. Matlala. But anyway, unless you want to comment on that, Commissioner Baloyi wants to ask a question.
Chairperson, as I said, those facts are facts that General Mkwanazi rely on, that he says he obtained from my client. And we say what he relies on, you should not accept. And we can show you in due course why you shouldn't
We've not accepted
It's just one
anything.
example.
We've not accepted anything at
No,
this
but
stage.
I'm saying to you,
Ms. Fanny.
it's just one example.
Yeah.
If I can, unless you want to hear me.
Commissioner Baloyi has a question.
I just want to make sure that I understand what you're saying. I've understood you to say that you want access to the negotiations and the documents and everything that went on in the lead up to what would have been a plea deal that is approved by the court. And you say because you haven't had access to that, you're unable to get Mr. Matlala to respond to the notice that he has been given. Did I understand you correctly?
Indeed, because in that process that leads up, I'm sure, Commissioner, you've gone through those processes yourself. There's always deals that are made.
Your microphone is off.
Yeah.
Sorry, there's deals that's made. And that process to come to a finalization of a 105A involves a quid pro quo. And I need to see what the quid pro quo was.
But what does it have to do with the statement that must be submitted to the commission?
Because let's
let me finish my point. That process has concluded, even if what you refer to or what you describe as the quid pro quo were to be relevant to the answers in the statement to be submitted to the commission, which I'm not saying they are, even if they were to be relevant, that process has concluded, has been declared in accordance with the law to be null and void. So for all intents and purposes, it never happened. That's what that concept means. Why is that a hurdle to Mr. Matlala submitting his statement, answering specific questions that have been put to him, and you know that in answering those questions, he's entitled to say, I don't know anything about this, if he doesn't know anything about it. And the assumption that we must make is he's going to be truthful in his responses. And if he doesn't know, that's what it is. Why are the notes and the documents that comprise or that constitute what you say is the quid pro quo, why are they relevant for our purposes?
It's highly relevant because let's speculate. I don't want to go into detail, but let's speculate for a second. In order for them to offer this deal, they sit around the table and they say to my client, we want information on A, B, C, and D. And A, B, C, and D forms part, let's say, of your list. But A, B, C, D is not part of the plea agreement. That is the deal that we cut here. You give us this information as an example, and we will continue. We will enter into this deal with you. So, for instance, if there is, let's say, a Section 205, Section 204 affidavit opposed to, I want to see that because I want to see in that what transpired. Or what was admitted in that statement, number one. But number two, I want to see, and I feel very strongly about it, what transpired during these plea negotiations. Because in law, normally what happens, it's recorded. Because I have been quite vocal about the fact that, I'm trying to choose my words very carefully. The process that was followed, I've made it plain to you, I was not going to be involved in it because I didn't trust it. That's the 105A process. And subsequently, I'm even more concerned about the process that was followed.
I understand.
And what I'm saying to you then is, in that negotiations, names could have been mentioned, admissions could have been made, evidence or Yeah, he could have disclosed evidence to them, and I
that's-
can't deal with it if I don't see what
But
happened
that's
there.
information that's within Mr. Matlala's knowledge. I don't understand. I don't quarrel with you wanting to know for your purposes. For your purposes, I don't take issue with that. So you don't need to persuade me that you want to know, you're concerned about how that process was conducted. That's not the issue. The issue that I'm raising with you is specific questions were asked of Mr. Matlala to speak to in his statement. And those issues are the issues that have been identified as relevant to our terms of reference and for our purposes. What I do not understand from you is what is the problem or what is the hurdle to Mr. Matlala answering those questions if you do not know what happened in the negotiations? Because where I'm sitting, that negotiating process has nothing to do with us. It's completely irrelevant for purposes of the commission and getting the answers that we require from Mr. Matlala. Of course, we know that Mr. Matlala has the privilege to claim self-incrimination. I will not answer this question because it will incriminate me. I have a trial coming up. We have experience in this commission about that. People have appeared and raised that, right? And we abide the law when it comes to those issues. What I don't understand in the long engagement with the chairperson that you've had is why it is that until you have received the notes and have an understanding of what happened in the quid pro quo, or what it is that was given in a process that, by the way, is null and void as matters stand, we could never, as a commission, you know that, we could never make any reference whatsoever to what happened in that process, even if we had insight into it. We don't have insight into it. We don't know what was discussed. We don't know what documents were shared, what information was shared. But even if we knew that, we could never reference that because that is an entirely separate process from our process, but that process is now null and void. So nothing that is said in that process comes before us by virtue of having been said in that process. If you accept that to be the correct position and the position of law, not just our conduct, but to be the correct position of law, you haven't said or explained why Mr. Matlala cannot submit his statement, answer the questions in whichever way he chooses, answer the questions asked of him until you've had insight into what happened between him and IDEC. The simple proposition being, he's been asked questions that are presumably within his personal knowledge, and he can give you instructions about those. And where he has no personal knowledge, he can say, I know nothing, and he'll come and tell us that. I don't understand the basis on which you are resisting. In fact, you say, I can never advise my client to answer questions. Well, it's for your client to make the decision whether to answer. Clients work on counsel's advice. It's not you who's answering questions. It's him who will tell you, this is what this question means. And you will say to him, well, that incriminates you. My advice is you don't give them that answer because it incriminates you. It's ultimately up to him to make the decision, not for counsel to say you don't answer because it incriminates. So far, you haven't said to us, Mr. Matlala refuses to answer the questions that you have given to him. You haven't said that. Your case throughout is, I need to see what was discussed with IDEC, which I say, and I say it firmly, it's completely irrelevant for purposes of your postponement and for our purposes. You keep on saying that. But in fact, what you should be saying to us is Mr. Matlala refuses to submit a statement to the commission because of ABCD. Then we deal with it on that basis. Thank you.
Commissioner, there's a few issues. The one thing that I've noted in the 10-6 that you, I assume, take quite seriously, there's a specific question that says, has any person tried to influence you, intimidate you, etc.? Now, you cannot say to me that that is not relevant to the Commission's work.
The answer can only be yes or no. And the rest would be the detail. If we are interested in a yes, if he says, yes, someone has tried to intimidate me, the commission may well follow up when he presents evidence and say, well, give us the detail of that intimidation. But the answer is yes or no. There's nothing, there's no privilege about it. There's absolutely, and it's a matter that is within his personal knowledge. It doesn't depend on you seeing the documents from IDEC. It's an answer that Mr. Matlala is in a position to give to you. So it's a bad example that you're choosing.
No, I respectfully disagree with you, because if there are, if for instance there's intimidation, or for instance if there's undue influence, with the greatest respect, I've come across, and I've got no problem that you yourself have come across people that do not understand that what they are subjected to is undue influence to get to a point. So I stand by my answer previously. The other issue that I want to raise with you is, as a litigator, we've got ethical obligations when we deal with clients to ensure, and you're right, I advise my client, that is my duty. But I do not know of a single attorney or an advocate in this country that will allow their client to depose to an affidavit if they're not satisfied that what is in that affidavit is correct. We all do this. We do litigation, we run trials. That is our ethical obligation. And if the issue is then that I am obstructing the process, if I want to put obstructed in inverted commas, by insisting on making sure that what I have is correct, then blame me. Don't blame my client, because I believe that in acting as I am, I'm carrying out my ethical obligations. I've been doing this for long enough, so have you, to know things are not black and white. There's a vast grey area in between. And I want my client to come and assist the commission, but I want him at the end of the day to do so free of anybody coming and saying, you're committing perjury because we've got something to the contrary. I want him to come here without later on falling foul of a previous inconsistent statement. It's my job to make sure that that doesn't happen.
Can I ask you this question just to make sure that I understand your position? Is your position, and Mr. Matlala, when I say your, I really mean Mr. Matlala because he's the client, is your position that until you receive the material from IDEC that you say you need to see, what was given, what was offered, until you receive that, this commission will never receive a statement from Mr. Matlala and he will never testify? Is that what you're saying?
No, that's not what I said.
Then what is the relevance of the IDEC background material in a process that has been declared null and void?
Maybe I must just go one step further and say that I have discussed with my learned friend, and I actually didn't want to go there, that we can sit down at some stage and try and work out some of these issues. But I'm saying to the Commission that all we want is we want an opportunity to comply with the 10.6. I've never said we're not going to comply with that. We want an opportunity to do so. The second issue is, and I want to almost...
Sorry, what is the opportunity? I think...
I want to postpone it.
I want to make sure that we understand what it is you are seeking from us commissioners. When you say, you are not saying that until you've received the IDEC material, Mr. Matlala can never submit a statement and he can never testify. You're saying that's not your position.
My position is not, it doesn't only relate to IDEC. Can we just go one step further?
Let's take it one step.
It doesn't only, but let me just go. No, it's on.
Thank you.
It goes further. The Commission is in possession of recordings that was only disclosed to us. So
hold on. I want us to do one step at a time so that we tick off what is the issue. If we've resolved an issue, we both agree this is off the table now. Now we are going to a different topic. So, I know that in your affidavit you do speak to recordings and transcripts. We will still get there. You haven't engaged with that. I just want to be clear, because my understanding from the time when you were engaging with the chairperson, and hence my questions that I've asked of you, my understanding of your position was, and still continues to be, that until you have received from IDEC, whenever that will be, if they will ever give you that material, until that point that you've received that material, Mr. Madlanga can never depose to a statement, because you would not let your client depose to an affidavit where in future he gets met with previous inconsistent statements and all of that. So I ask the question so that there's absolute clarity about what it is that we are dealing with. Is your position, let me repeat, is the position that you are adopting that until you have received the IDEC material that led to the now collapsed plea deal, Mr. Madlanga will not be in a position to file a statement to the commission, and Mr. Madlanga is not in a position to testify before the commission?
Chairperson, of course, that is my position at this point in time, because I'm ethically bound to act in that manner. Again, I say to you, I cannot think of any other council that would act differently than I do. So, but
Yes.
This is not an impediment, because I truly believe we can get the information relatively quickly. So I'm saying to you, please just take into account, this plea deal collapsed on Monday. It's Wednesday. So we've got this very short period. But that's not the only thing that I say.
No, don't go to the other things.
Right.
I'm more interested in the question of principle. I want to establish the principle. It's important to us. If by the time we finish here, you rise and your position is until he has received the IDEC material, or you have received the IDEC material, whenever that will be, maybe tomorrow, maybe day after tomorrow, maybe next year, maybe not ever. I want to establish the principle to make sure I understand the principal position. Is the principal position that until you have received and considered as his counsel or his legal team, until you've received and considered the IDEC material, Mr. Madlanga will not file a statement and he will not testify? Is that the position you are conveying to us?
Until such time I am told by any person in the legal profession that I'm wrong in going to a point where I say part of what I'm doing here is to protect my client's rights. I stand by that.
Yeah,
I
Miss-
say it is
No, I
taught.
must insist, Ms. van der Heever, I've asked a direct question. Let's stop this going around. I'm not asking you about being advised by somebody, being told you're right or wrong. And I haven't yet expressed a view that you're wrong, by the way. I'm not saying your position is wrong, right? I'm still at the point where I want to understand the position. And it is a yes or no kind of question. You have motivated, you have argued, and you don't need to do that any further. I'm now at a point where I want to understand, is the position that until you have the IDEC material, Mr. Madlanga will not file a statement and Mr. Madlanga will not testify? The answer is a yes or no.
My instructions are that we will file a statement as soon as possible.
What is your answer to my question?
I've told you, Commissioner.
So you will file a statement even if you do not have the IDEC
That is
material?
my instructions at this
Okay,
point.
that you will file the
I got
statement.
instructions from my attorney to deal with it in
Thank
that
you,
regard.
thank you.
May I just, before Commissioner Kumalo asks a question, he says his point is now covered.
Okay.
You said earlier you had a discussion about timelines or the timing. I just want to find out at this stage, before you continue with the rest of your submissions, to find out by when the statement that you say can be filed, by when will that be filed?
Chairperson, I've not
I know perhaps
arranged
it's
for
something,
yeah,
it's something you may want to engage Ms. Silo about, but I would just like to hear from you.
May I take an instruction just for
Yes, yes.
We think we can do it in 2 weeks. Of course, please take into account we're starting a trial on Monday. And that is, of course, also premised on the fact that we get the recordings that's been referred to and relied on by certain witnesses in the commission. And I've discussed another issue with my learned friend, but I'm not going to deal with this on the record. Me and her have managed so far to, between us, sort these issues out. So if it's convenient and if so permitted by the commission, my attorney says that we can probably do that in the next 2 weeks. Because, of course, maybe just for the record, we can also obtain some of the information through the erstwhile attorney. So.
On this and possibly any other issues that may require discussion between you and your colleague, Ms. van den Heever, we'll give you time, so we will adjourn before any ruling is made. But I don't think you were done with your submissions unless you tell us that you are. If not, you may continue.
I think my submissions are quite clear pertaining to the upcoming trial. I think we have the right to be presumed innocent. This commission is watched by many, many people, and I'm just afraid, as it goes, the questioning of him, and I'm not necessarily saying by yourselves, but I know my learned friend might give the perception that he's guilty, and he will go into his trial with baggage, and I'm trying to prevent that. I've set out for you, I think, quite clear the issues that we are dealing with. And then, of course, I'm asking you to pay serious consideration to what is contained in the opinion that we've urgently obtained for you, because I find it very persuading. I hope you do too. And we are endeavoring to deal with that issues the best we can. Thank you very much. Sorry, Chairperson, my attorney has just asked me to emphasize the point that part of the delay had to do with the recordings that was not given to us, and which is quite important.
I'll give you an opportunity. We just... Ms. van den Heever, we heard what you say, and what you said you wanted to emphasize, unless you want to add to that.
Just been asked by the attorney to emphasize the point. Those recordings are vital. They've been referred to by witnesses. They've been, and the day we received the recording, and I thank my learned friend for her intervention in that, was the very day that the statement was due. As you can imagine, we've got limited access to the client. I personally had to phone the head of CMAX to ask, please, can the attorney go in? And he's not even finished listening to the recording. So it's also impeded quite a bit of the issues. And then lastly, maybe I should also emphasize that you please take into account, Commissioners, that whilst this process of the 105 was unfolding, we were not part of it. We couldn't get instructions on it because somebody else was dealing with it. So even if we wanted to, we were basically, and I say this respectfully, cut off from dealing with the issue for other reasons that I assume will at some stage come to light here. Thank you very much.
Thank you, Ms. Van den Heever. Ms. Sillo.
Thank you, Chair. Chair, I have a witness whose testimony was deferred to later in the morning, and I'm quite mindful of that witness. So that constrains me significantly as to how I respond. So I will try to be as brief as possible, and in so doing, perhaps to assist the commissioners. I would like to start with where my learned friend ended, which is an offer to file the statement in 2 weeks. That effectively takes care of the first part of the ruling, or was it the second part, but one part of the ruling of the 7th to file in 2 weeks. We have spent over an hour engaging, or my learned friend engaging you on matters that don't get to that conclusion. That's where she ought to have started and would have saved significant amount of time. I say this because on reading the affidavit in support of the application for postponement, one must bear in mind that we appeared before you on the 7th of July. Everything that is in that affidavit predates our appearance. And it is at that appearance, notwithstanding the facts as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument, if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say, those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Can you,
Now,
sorry,
yes.
Mr. Lo. Can you please make me understand something Ms. Van den Heever said on the 7th?
Yes, Chair.
Ms. Van den Heever indicated that she was agreeing to the filing
Yes.
by the deadline that was indicated, something like subject to the reservation of Mr. Matlala's rights. Even as she said that, I wasn't sure in my mind what exactly that meant. What was your understanding?
My understanding.
Of course, maybe I should have asked. I should have put that question to Ms. Van den Heever.
It's a subject, of course, to Ms. Van den Heever confirming.
Yeah.
But I had understood that the proviso was file on the 8th, subject to Mr. Matlala's right to supplement statement filed. That was the reservation made.
Because there could not be an undertaking to file, but at the same time not to file. An undertaking
yes.
not to file.
And in fact,
It's even wrong for me to refer to the latter as an undertaking. Yeah.
And in fact, that proviso was discussed amongst ourselves because of the tight timeline they then had to file by, having missed previous deadlines. The only way to cure any potential prejudice to Mr. Matlala was to agree and place on record that he reserves the right to supplement. We thought it is a natural way to go, and he's entitled to supplement whether or not he has reserved that right in any event. But to the extent that it was necessary to articulate it in no uncertain terms, we were agreed to that. So that was the proviso, Chair, that was attached
All right.
to the filing.
Please continue.
Thank you. So at the end of the day, what the legal position is regarding Mr. Matlala's constitutional rights, as posited by Leonard Friend, is irrelevant for our purposes. She may very well be correct, she may very well be wrong, but it doesn't advance the issue any further. Those rights existed on the 7th when she made the undertaking, unless she suggests that they have since or very recently been earned. I listen carefully and I resist the urge to argue that this is a moving target. And each time we think we've got the target, then that target is going to move. And we are continuously chasing a rabbit we cannot catch. And Chair, I implore you and commissioners to please put an end to this. Witnesses come here and make undertakings. They give dates. We work on a very tight time schedule. Either witnesses respect the rulings given by the commission and adhere to those rulings and file, or either appear on the dates that have been either directed by the commissioners or on which they have made undertakings, because otherwise it makes the work of the commission impossible. We now have to change things about. We now have to find another slot for Mr. Matlala. We now have to plan for him when to give an affidavit, a statement, and to find a slot. And all this time, it's in circumstances where this commission has got a limited time span left to it. I am concerned about the approach being adopted by Mr. Matlala's representatives, and I don't think it is particularly appreciative of the challenges that the commission faces. As to whether or not the commissioners and the chair will permit the rulings handed down to be wantonly disregarded as for the commissioners to decide. But I wouldn't be surprised if the commission holds a dim view of that. So, the difficulty we have, or I have personally, listening, is, and I do accept that I possibly misunderstand Ms. van der Heever. The plea agreement with IDEC, the aborted or stillborn plea agreement with IDEC, at the risk of stating the obvious, that has got absolutely nothing to do with this commission. What this commission is interested in is its terms of reference. It's interested in the issues that were raised in the Rule 3 notice that was served on Mr. Matlala, as well as the subsequent Regulation 10.6 notice. That's all where this commission is interested in. I'll rephrase that. That is all the evidence leaders have indicated they are interested in. The commissioners may expand those issues. What position Mr. Matlala assumes in response thereto is his choice. We desperately do not want to be a part of a discussion on how does he respond to a particular question. If a question posed invites a defense, a Section 35 of the Constitution defense, so he must state, and then we will deal with the defense as raised when he appears.
And as I put it to Ms. van der Heever, it cannot be that everything he could ever say is covered by or by Section 35.
Indeed.
Or bears relevance to the Section 35 protection. It can never be, and Ms. van der Heever accepted that.
Yes, Chair.
And facts are facts, and they should not change in accordance with whatever it was that went on under the plea deal. But as Commissioner Baloyi said, that's null and void anyway.
In any event. And once again, it depends on whether I understood her correctly. It gets worse because now it sounds like the commission shall be hamstrung by any plea deal that Mr. Matlala may choose in any criminal trial, whether ongoing or in the future, to conclude. So, effectively, if Mr. Matlala were to tomorrow face 5 charges in five different criminal trials, and he considers whether or not to conclude a plea deal in any one of them, then this commission is hamstrung, unless I completely misunderstood Ms. van der Heever. My understanding would be, I don't believe she would suggest that. But at the same time, then I struggle, what exactly is being suggested regarding these plea deals? And once again, I have no clarity. I submit, commissioners, that the only position to assume is we have nothing to do with any plea deals that Mr. Matlala chooses to conclude anywhere in any court. He has 2 defenses in this commission. It's a Section 35 defense, or buttressed, in fact, by Section 8, sub 2 of the Commissions Act, that anything he says that would incriminate him cannot be used against him in any criminal case. So he's got 2. He can raise them. So why we are having a debate about plea deals and whether or not his legal team understands the facts that underpin such a plea deal is a challenge to me. Now, the offer, mindful of the time, made to file in 2 weeks, I can accept. In any event, it's up to the commissioners. However, the offer, if I understand it correctly, sounds to be conditional, and this is what the condition is. It's dependent on whether or not they get the requested information from either IDEC to enable them to answer the questions posed. If I misunderstood, because I think Commissioner Baloyi indicates there's shaking her head as if I misunderstood her.
I think the ultimate position was they will file a statement.
If it is wholly unconditional by a specified date, then I'm happy. Because my concern was that if they do not get the required information from IDEC, or IDEC just outright refuses, then they would be entitled in law to approach a court to compel IDEC to provide such information if they have a basis in law to do so. And if that court case is unfavorable to them, there are appeal proceedings. So the question would be, do we await that information and the challenge to right to that information to run its course until the Constitutional Court before we get a statement? But I will accept what Commissioner Baloyi says the filing in 2 weeks is unconditional. If that is the case, then we just need to set a date, and if the statement is not filed, we shall be back before you, Chair, and I suggest that the consequences will follow. What then must happen now is to lock in a date, as we did of the 15th that has now collapsed, as to when Mr. Matlala will appear. And I say so because we as the evidence leaders have to go rejig our program and accommodate the new dates, while at the same time making sure that there is sufficient time for everybody to prepare for Mr. Matlala's appearance before you.
Would the preference be for the postponement to be to a specific date or a date to be determined?
No, Chair, I would prefer a specific date at this point.
Specific, all
Yes.
right. All right, please continue then.
Thank you, Chair. And to assist perhaps the commissioners to consider a possible date, my learned friend will confirm, I understood that the upcoming trial that starts on the 20th.
Just a minute.
Yes, Chair.
I think on your last point about the date, I think it would be better for you and Ms. van der Heever to engage, and then, which of course would necessitate a stand down. And when we come back, hopefully, we'll get an agreed date.
Oh, no, I'm happy with that approach,
yes.
as long as I come out of this hearing with a ruling on a date. Chair. However that point is reached is irrelevant. I'll accept that, Chair.
Any further submissions?
No, Chair, I think that will suffice. I'm looking at the time. As the commissioners are aware, there's another administrative issue to deal with before my witness returns to complete his testimony.
Any reply, Ms. Fanani?
I'm going to be very brief, Chairperson.
Yes.
I'm not going to go back to the issues of the plea deal. I've got experience in that regard, and I know it's important. And at some point in time, I will demonstrate to you what the importance of that is.
Yes.
The second thing, my learned friend says that subsequent to the date of the 7th, nothing happened. The affidavit sets out quite clearly what happened subsequent to the 7th. The 13th, we were back in court. There's also the issue on the 8th, the recordings were disclosed and what happened there. So my learned friend is not correct when she says there's nothing. It's been set out chapter and verse what transpired from that date on. And the thing that's quite important, Chairperson, is I don't believe this commission, and I've said it before, as you recall, we're not here to ambush witnesses. And it's for that reason that I'm entitled to ask, if you're in possession of certain material that you wish to use against my client, I'm entitled to ask for it. Because that way, we level the playing field. So that also needs to be taken into account. Lastly, you were quite right. I did reserve my right twice.
Or just before you move to a different point, wasn't everything that Mr. Matlala required given before the 7th of July?
We said that there must be certain recordings. We then given 13 voice files. We then said it's clear somebody went and extracted, like cherry-picked and given us 7 voice files. We now want the complete recordings from which these were extracted. We were then given on the 8th, I think, recordings, 2 recordings. There's in fact a 3rd recording that was not given to us. Then we were handed over, I discussed it with my learned friend, and she made some inquiries. We were given a transcript, an unofficial transcript of the one. So, and these are long. The one is 6 hours and the others together is longer than that. So, and the client must sit and listen to it because he needs to ensure himself. So that process wasn't even concluded. And then lastly, as I said, it's just an issue of, I did reserve my right because I foresaw what was going to happen at that point in time. It was not a condition I will file and then amplify. I just couldn't because at that point I still hadn't had any access to the client to discuss any of the issues relating to, as I said, let's call it the Medicare 24 matter. One more thing, Chairperson, I'm going to ask you and the commissioners to consider the following. I'm going to ask that we be assisted and that an order is made that we get access to the client over weekends with electronic devices, in other words, with the computers, to assist us in dealing with all of these things. It's very difficult if we can't do that. It's the times that you can see the client is limited. There's only a limited number of legal practitioners at any given time that can see the person. And if you were to see him in the normal way, there's a thick glass and you can't listen to recordings. So we would like, if there's any way that you see open, that we be allowed for this weekend and the next weekend to get access. After that, we won't need it because the last weekend would be just before the filing. Because we're also starting on Monday, he gets transported, very limited time in court because we're running the trial. So what we can do is we can get drafts exchanged that he can look at that, but to finalize it, we'll also need to have access to him next weekend at the prison.
How is it done for purposes of the criminal trial that's commencing? Is it next week?
We've had consultations long before. It's actually a much simpler matter than anybody has made it out to be. And that's why for that it was easy. We've given the client the dockets that was disclosed, and when we had opportunities, we've discussed with them our defense, our plea. So that was, and we had two person-to-person meetings that was allowed by the head of the unit. So we could actually go in with computers and have those. But for some reason, I think because of what has been transpired, we are not getting access that easily anymore. I can just speculate why suddenly, after things have started going a bit differently. So all I'm asking is if you can assist us in that regard, we'd appreciate it.
Yeah, I think something like that would have to be dealt with administratively. I cannot make a ruling here. But anyway, it's not that I understood you to be asking for a ruling.
Yeah.
Because, for example, I do not know what prescripts correctional services may put up and say, we can't comply.
No, so all I'm basically asking
but that should never be understood to say, after agreement on a date, what happens or does not happen will then be a basis for saying, no, we are not able to file because. Please continue if there are further submissions.
Simple, we will do our best, but maybe something from the Commission side that we should, without making a ruling, that from DCS side that they should do whatever they can to assist us. I think that would go a long way. That would give us something in the hand to now go and do from our side what we need to do. Thank you. I've got nothing else.
Nothing else.
I agree with my learned friend then that we discuss inter partes the date.
Yes, all right.
Ms. van der Heever, without getting into it, I just want to know its status. The opinion letter, I'm not getting into it. Was it filed just for the purpose of today's postponement? It was to deal with just today.
Oops, it doesn't work anymore. Oh, there it goes. It was done for today because of, as I said, that's all I wanted to say.
Yeah, it doesn't go beyond.
There are other reports and things that's available. That's been drafted. We have been communicating with the head of prison with regard to the issues. But I don't want to go into that further at this point in time.
It was just for today's postponement.
For
That's
today,
all I wanted
and the relevant part of it, you'll find about the issue of. Yeah, I mean, you've read it.
Leave it there. That's fine. Thank you, Mansard.
Chair, if I may, for the record, to correct for the record and posterity, Ms. van der Heever speaks of being provided with random extractions from recordings. That's wholly incorrect. The recordings that were provided were recordings that were played in this commission during the testimonies of witnesses. As we do when we provide our Rule 3s, we provide the evidence that implicates the particular witness who served with a Rule 3. Those are the 13 recordings that were played in here. They were not random. Nobody went into the recordings and decided they liked the sound of the clipping from 1 hour 15 to 1 hour 17 minutes. So that is one. Those were provided on the 18th of June. They were given to Mr. Matala. It is only on the 7th of July, after the ruling, and their statement is due the next day on the 8th, that they require the complete recordings. And they were duly provided on the 8th. So it is not like information was denied them or we failed to respond positively to any request for information made. Each time it is made, it is given. The inescapable conclusion is nobody listened to those 13 clippings when they were provided, and therefore, because if they did, they would have made the determination at that time already that they require full clippings in order to prepare a statement. Thank you, Chair.
Maybe that just on that issue, Chairperson, what we immediately on receiving those recordings send it off to an official transcriber. It was in vernacular. It then had to be typed up and then transcribed. And then upon seeing the client with the computer, it's only then that we realized that these were extracts from various other recordings. And it was only at that point that we could approach the Commission, the evidence leader, my learned friend, and say we want the full recordings, because we were then informed that it's extracts from other recordings.
We will, thank you to both of you. We will, let me just look at the time. We will adjourn and come back when you tell us to, and we hope that we'll be within a very short time. We are not taking the tea break at this stage.
Noted, Chair.
And this is for a discussion between the two of you on the date of the hearing and two, the date of the filing of Mr. Matlala's statement.
Thank you, Chair.
Let's adjourn.
A statement shall be filed on or before the 29th of July 2026, and that his testimony is stood down to starting the 1st of September 2026. So the hearing will commence on the 1st, and depending on the issues that we have to engage with, that could run into subsequent days. We would request that we do not commit to specific dates thereafter, but there's an appreciation that we are not fixing one day of the 1st. It's from the 1st. Thank you. Thank you, Chair.
Ms. Lo, is it the understanding between you and Ms. van den Heever that if we need to roll over to the next day, we won't run into diary issues that Ms. van Heeren had not prepared for that?
Exactly, Commissioner Baloyi, and hence I express his date of appearance as from the 1st. So the agreement is the 1st and succeeding days as much as are required in that week. But I don't want to give, I won't say the 1st to the 4th, it could very well be, but we start on the 1st until he concludes his testimony. Uninterrupted, thank you.
Thank you.
Chairperson, I indeed confirm that that is the agreement. My understanding is that we start on the 1st and then it will continue until such time as we've reached the end. If I may just use an opportunity to just deal with one issue. I got a random message from somebody on my phone telling me that I'm not allowed to shout at you, Chairperson, or the other commissioners. I just want to make it plain that I don't shout, I just speak very loudly. Most people know that. So I am sure you didn't perceive it as shouting, neither yourself nor the other commissioners I spoke to. Just for people that don't know me, I speak very loudly. It's not shouting. Thank you very much, Chairperson.
If it gives you any comfort, Ms. van den Heever, let me tell you that a judge, when I was appearing in the Mthatha High Court, once shouted at me saying I should not shout at him. So
Then we're in the same boat, Chairperson. I'm very happy to hear that. Thank you.
thank you. Oh, one other thing, at least based on the agreement that has just been conveyed to me, I assume that you will not be insisting on reasons for the fact that we are saying the hearing will be continuing.
I do not need
Thank
any
you.
reasons. May it please you. Thank you.
Thank you, thank you. I thought I should just take care of that because there was the muted reference to the possibility of a High Court application. So one might say no reasons were ever given for an application that we made.
Like they say, I don't roll that way, Chairperson.
Thank you. I make the following ruling. Mr. Matlala must file his statement not later than 29 July 2026. And that's one. Two, the hearing of his testimony is postponed to 1 September 2026 to continue until the hearing has been finalized.
Thank you very much, Chairperson.
Thank you.
Thank you, Chair.
Thank you. Mr. Matlala, Ms. van den Heever, you are excused. And because we are continuing with you, Ms. Sillo, you are not excused.
Chair,
Is it?
it's not with
Oh,
me
for
for the
later.
next admin issue, yes. So thereafter I come
Still
back.
you are with us later in the day, of course.
Yes,
But
thank
thank you. let's adjourn and come back at midday, 12.
Thank you, Chair.
Good morning, Mr. Shaskalson. Good morning, Mr. Premhead.
Morning, Chair.
Morning, Chair. Morning, Commissioners. Chair and Commissioners, you'll recall that 3 weeks ago, Mr. Karim was postponed to today's date. He's not here today, and we received a doctor's note yesterday that refers to his admission to hospital on the 17th of June, which is more than a month ago. When we received that doctor's note yesterday, it seemed to explain Mr. Karim's apparent inability to appear today, but it didn't explain his inability to answer, at least in part, the Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Karim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Karim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Karim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Karim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Karim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The 2 reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Karim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Karim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Karim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Karim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Karim's appearance or non-appearance to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Karim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Jaskelson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
So that is our request, Commissioners, that the matter stand down to be decided on the basis of a formal postponement application on Friday.
Thank you, Mr. Shoskelson. Yes, Mr. Premier.
Good afternoon, Chair. Good afternoon, Commissioners. 5 brief points in reply, if I may. Firstly, do you have the Commission's correspondence bundle? I was handed one about 10 minutes ago by a Commission representative, but it's called Karim Suleiman Correspondence and Sundry Documents Witness Bundle. I'm going to refer you to the confidential medical report in that. I'm not going to discuss the contents, but if you can turn up page 128 of that medical report, when you read paragraph 1 of that report, that will deal with my learned friend's contention that there's an inability to explain attendance. And when you read paragraph 2 of that same report, particularly lines 2, 3, and 4 of the second unnumbered paragraph, that is a direct response by a medical practitioner as to why, potentially, there's an inability to give answers. So insofar as my learned friend says there's just no explanation at all, that's contradicted by the medical evidence of an expert in a particular field of medicine, which my learned friend is not. That's point number 1. Point number 2, my learned friend must choose his words very carefully with all due respect, because my learned friend talks about hundreds of millions of rands, companies that are continuing to service the state, multi-million rand businesses and so on, and he uses the quantum of my client's otherwise legal business to evidence some or other gratuitous behavior in front of the Commission. Until such time that a court orders otherwise, that there was unlawful business dealings with the state to the tune of those hundreds of millions of rands, the fact that there's business that may or may not be done to the tune of hundreds of millions of rands is neither here nor there. So my learned friend must choose very carefully his words in elevating otherwise perfectly legal facts to be weaponized into some sort of smear, potentially, against my client and otherwise lawful activity. The third point that I would say, in respect of Mr. Karim's undertakings to give the evidence, is you'll know that Mr. Karim, if you'll give me 1 second. I'm indebted to Ms. Madlanga. On the 13th of April, suffered the medical incident, and at least on our version, he has been in medical treatment since then. And so his ability, notwithstanding undertakings whilst given in the box, must be construed having regard in particular to that second paragraph that I referred you to on page 128 of the bundle. Can I say, in number 4, in respect of these whistleblower reports and the alleged corroboration or not corroboration that has occurred or not occurred, and this is a two-part point, so you'll forgive me. The first part of which is we only learnt about these facts today. I know my learned friend says he also only learnt about these facts today, but apparently these social gatherings were known about before. And it's the first time we're learning about these things today. And I must place this on record, in as much as I don't for 1 minute question my learned friend's ability to rely on those allegations to raise a question about Mr. Karim's position in front of you. We would respectfully submit, and I know earlier there was an exchange about whether respectfully is respectfully or not respectfully, but I'm respectfully submitting.
I'm happy you were listening.
Yes, no, the commission is warmed up by the time I come here, so I know what I'm walking into. The point that I would make is that it's unfortunate we're learning about these in an open proceeding of this kind, and that these demands about what this formal postponement application needs to entail in an open session of this, rather than to have had an opportunity, even after either a stand down or a postponement was asked for today, given that the client is not here because he's presently in the hospital. So it's unfortunate we've learnt about it in this way, but my learned friend and I throughout the morning have been talking intensely about what he can give me and what he can't give me, and whether he's going to give me the CCTV footage he's already got in his possession or he doesn't. Well, I don't think we're in agreement on that, but my learned friend very kindly my learned friend has very kindly given me the license vehicle registration of the vehicles that were apparently transporting my client or not transporting my client yesterday, and we'll deal with that in due course. All I'm saying is that the manner in which we've learnt about this is regrettable, and the reason it's regrettable, and this is the second point of my fourth point overall.
How do you suggest you should have learnt about it?
That is a segue, thank you, Chair, to the second point I want to make under this, is that with all due respect, I'm now concerned that we are inadvertently using the postponement application and the allegations regarding the movements of my client or otherwise as a mechanism through the back door to undermine the otherwise unimpugned medical evidence in front of you. And Chair, you asked me how should we have learnt about it. With all due respect, I don't think it's for my client necessarily, unless you order otherwise. If you order it, well, then we have to do it. But if you don't order it, it's not for my client, with all due respect, to answer these accusations in the ether in the way that they are, where the overall purpose or effect is to create doubt about the medical excuse.
That's a different issue. You raised an issue, or rather, you complained about having learnt of the information in the manner in which that happened. So I'm asking you the question, how do you suggest you ought to have gotten to know about the information? That's different to what you are saying.
Yes, Chair, thank you. The way in which we should learn about it, and I know Chair says to me it's a different issue, I will respectfully say it's not a different issue, is because if the purpose or effect of that accusation is to raise doubt about my client's medical condition and whether there's a legitimate excuse for his attendance or non-attendance at the commission, because that's what the sting of that accusation actually is, then actually the shoe should be on the other foot, in the sense that it should be the commission, the evidence leaders, bringing an application where they raise this evidence in the round of questioning the medical advice or otherwise, or the medical reports or otherwise that have been tabled in front of you that otherwise serve as the excuse. It's not the hill I'm going to die on. All I'm simply saying is that I'm concerned that the way in which these accusations now have to be dealt with is almost reversing the onus that otherwise falls on my client.
That still doesn't answer my question.
I apologize, Chair.
Yes. The question of how Mr. Karim must respond is something other than your suggestion about maybe the word I'm going to use will be strong or too strong. The impropriety that you suggest with regard to how you came to know is what I am addressing. That has nothing to do with how Mr. Karim then deals with the information. So my question is, how do you suggest this information ought to have landed on your or Mr. Karim's lap?
In writing and particularized, so that it's formally placed in front of us, rather than as what happened between my learned friend and I, which was a conversation between colleagues regarding these issues that are now being raised. So that's when I talk, and Chair, with all due respect, impropriety is a far higher word
That's exactly
Yes.
why I
Yes.
said maybe it's too strong a word.
Yes,
Yeah.
because I'm not,
But,
I'm not accusing my learned friend or anybody of impropriety. I'm just raising my concern about the manner, and then that's the direct answer.
Maybe instead of impropriety, I should have said concern,
Yes.
which is the word you've just used now.
Yes. So Chair, I think we're ad idem then that it's concern, not impropriety, and formally in writing, because these are very serious accusations, and I understand that my learned friend is under his collegial obligation to give me notice that he was going to raise it today at the hearing, but he could have perhaps, we could have reached some or other arrangement about being informed about this formally and then given an opportunity to respond. But we are where we are now, so that's water under the bridge, I suppose.
Yeah, I was going to say, why is it that the informal advice cannot serve the same purpose as written advice?
Well, I suppose because my learned friend is not the witness. So when my learned friend, and neither am I. So when my learned friend says to me, you know, these are the core of the allegations, it might turn out that some or other detail about that is going to change or not change, and there should never be a dispute between my learned friend and I as to what he said to me or what he didn't say to me. I mean, if my complaint is at this point only boiling down to housekeeping about the form of communicating the information, I accept that that might not be an issue which needs to detain the Commission.
The issue, as I understand it, is not so much about the interaction between the two of you. It's about Mr. Karim addressing what we are told has since been discovered.
Yes.
So the focus is less about the interaction between the two of you.
Exactly.
And the point being, if indeed it is true that Mr. Karim was at some food outlet out of town, I think reference was made to his vehicle or vehicles, I'm not sure now whether one or two or more. So point is, when you apply for the postponement, why is it, or rather when he, Mr. Karim, applies for the postponement, why is it that he should not, in the application for a postponement, deal with those? If he says, I was never out of town, I was never at this alleged food outlet, and therefore, my medical certificate stands, and it is to this effect. Nothing has changed. I do not see what the hurdle is, Mr. Karim, dealing with the new information on that basis.
Agreed, but I think that's also I'm sorry, Chair.
Yes.
May I respond?
Yes, please.
Thank you, Chair. But that's the point, with all due respect, is that, remember, when we arrived here in front of you today, it was on the basis of what was known before my learned friend disclosed the new information. But now what's happening is new information is being introduced, which may need to be dealt with to justify future postponement, but the basis upon which we're here in front of you today is the different historical facts, not the new facts introduced now.
But that's exactly why Mr. Karim is being afforded an opportunity. And it's not as if Mr. Shaskalson is saying, and we want Mr. Karim to deal with this now. No. And that's it. Mr. Shaskalson is suggesting to the Commission that Mr. Karim must be afforded an opportunity to file an application / affidavit dealing with these developments. So, in the light of that, I would suggest to you, subject to what you say, in the light of that, it should not matter much what you originally came here for today. Things have changed, and because things have changed, Mr. Karim is being afforded an opportunity. So unless other submissions are made, I do not see what the unfairness to him would be. Mr. Karim, because of these developments, bring an application which will be heard on Friday at whatever time. It could even be in the afternoon, and deal with these developments. Tell us why you are not able, for example, to provide the Commission with the information it required, or to give the necessary instructions to whoever may do so, to give the Commission that information. So in that application, he must deal with all of that.
That's why.
And issue, as I understood Mr. Shaskalson being, this information was requested a long time ago, and Mr. Karim has not provided it on the basis that he is not well. Now, these developments referred to by Mr. Shaskalson, at face value, suggest that Mr. Karim is going on about his life. That raises the question, if that be so, and underline if that be so, how can it be that he is not able, either himself to furnish that information or to do so through others? And he's afforded an opportunity to respond and say, I cannot, I simply cannot. And to do that, and to move the application on Friday. I'm not saying that's what we are going to rule, but that is what Mr. Shaskalson is submitting should happen.
Yes, Chair, and I accept that. That's why,
Yes.
that's why I placed manner and form no higher than a concern, rather than using that favorite A word of ambush, and also claiming trial prejudice and fair trial rights. I was, with all due respect, simply placing on the record a more subtle concern from my client. That's all. And that's why I've resisted putting it higher than that. May I just say that in respect of the face value concern and the timing of the evidence and the way Chair posits to me what Mr. Chaskalson put to you, Chair, you've already heard me on that page 128 paragraph of the bundle as the explanation. But insofar as and this is now...
Please take me to the relevant lines of the first paragraph. The first substantive paragraph, not the intro.
Yes, the first substantive paragraph is about whereabouts. So that's inability to attend, to use my learned friend's phrase.
In respect of the second paragraph,
yes,
you referred us to specific
the explanation,
lines.
Yes.
Specific lines.
If you look at the second sentence beginning on line 2...
Starting after. We're not going to read it.
No, we're not going to read it. Indeed
But
not.
Is that the one starting after?
No, given.
Oh, given.
On my side, I have given.
Okay. All right.
I'm indebted to Commissioners Baloy and Kumalo.
I thought you referred to the first paragraph as well.
Yes,
So I had no problem at all with the second or the last paragraph.
Yes.
So what I was raising with you was, please direct me to something on the first paragraph. So are you saying you said nothing about the first paragraph?
The Chair, just to be clear.
The first paragraph starting Mr. Karim.
Well, the problem is they both start Mr. Karim.
Oh, let me look. Has been. The big paragraph.
Okay. So
Mr. Karim
the
has
bean
been.
paragraph,
Yes,
if we can call it that.
Yeah, do you have lines you want to refer to?
No.
There?
In the bean paragraph is the whereabouts explanation.
Okay,
And if I have to point you to particular lines, I would say from the date mentioned in
Okay.
3, running on to 4, as it continues. And then there's an
Okay.
explanation there which I don't need to go into.
Okay.
And then in the second paragraph,
Yes.
the remains paragraph, not the been paragraph. In that paragraph, I would ask you to look at the second line, the second sentence starting given. And I would say that that second sentence, which runs on to line 4, ending before the word his, is the critical one regarding inability to explain. The third sentence, which starts his present, that also adds color, but the critical one is the sentence I've highlighted. So that's the face value explanation. That's the response to Chair's point about face value and explanation. But Chair, can I, on my fifth point, I said to you 5 points briefly. It's not that brief, but fifth point briefly, is the timetable. I've heard my learned friend where he's given 2 options for the timetable. He says 10 o'clock tomorrow, reply by 6 o'clock, Friday 9:30 for argument. Alternatively, if I'm not mistaken, he said 1700 hours tomorrow, 1000 hours, they'll respond the next day on the Friday, I think, and then we'll argue on the Friday afternoon. Can I just make 2 points about that? Obviously, the first one is obviously we're in your hands regarding your directive and the timetable for the hearing of that application. Before we entered the room, I did specifically ask my learned friend if he would consider our ability to have that argument next Friday, because you will know that in the correspondence there's consistently been the issue raised about our ability to take instructions directly from Mr. Karim and having to rely on the medical practitioner and the family. And so there might be practically some delays in obtaining the level of specific instructions that we have to now obtain. But as I say, I'm in your hands on that. You will direct as you need to direct. The second point, and I think my learned friend and I have reached an in-principle agreement on this, but if I'm wrong, no doubt he'll correct me in reply, is that Friday, insofar as, I'm just using Friday as the placeholder date, Friday, insofar as we end up needing to discuss medical conditions, hospitalization dates, even identity of the medical practitioner and the speciality that they may or may not specialize in, obviously impinges potentially on my client's medical privacy rights, and also around causing unnecessary public, in an open sense, public speculation about his state of being or not being. And I've already flagged with my learned friend that we might need to be, because for the exact reason that I can't read to you what the contents of the medical report actually says, I have to use all these sideways descriptions of directing your attention to content. It might be appropriate for us to have that debate, at least in camera, without the journalists and the outside world reading in, to the extent that we need to go into that medical history and the details. So never mind the timetable issue, Chair. I think in addition to, if you direct that we have to bring the formal postponement application in the way that it's posited, I'm giving advance notice to you as the Chair and the Commissioners, and I've flagged it and I've discussed it with my learned friend, and he was very understanding, I'm grateful, that we might need to then have that as an in-camera session so that my client's medical privacy rights are protected and his dignity is not unduly impaired as a result of what information we, as the Commissioners, the evidence leaders, and his legal representatives need to have a frank debate about in a way that still manages to protect him. So, Chair, those are, may I just check with Ms. Madlanga, who usually holds the purse strings?
Yes.
Ms. Madlanga says I've done my job, so it's fine. Thank you, Chair.
Thank you. Mr. Shaskalsin, any reply?
Brief reply, Chair. Firstly, in relation to the businesses, why I mention the businesses is not to say that these are unlawful earnings or that these earnings are, proceeds of crime or anything like that. It's to say there is a very substantial business group that is carrying on in the apparent absence of Mr. Karim. And if the group can carry on in the apparent absence of Mr. Karim, then it's not clear to us why we can't get, through a simple request from Mr. Karim, details like financial statements of 3 of those companies in the group, the identity of the auditor of 3 of those companies who we still haven't been able to ascertain from repeated requests to Mr. Karim. So if he can keep his businesses ticking over remotely from his sickbed, he can also issue an instruction that the information that exists external to him can be made available to us. And he hasn't done that for months now. The second issue in relation to the medical report is it's curious to hear my learned friends saying we haven't impugned the validity of the medical report, because last time we were here, you'll recall that there was a suggestion on the table that Mr. Karim should make himself available for independent medical examination, and we were told, oh no, you don't have the powers to do that. You're not a high court with powers under the rules, you can't do that. He won't make himself available without you, and you don't have the power to do that. So now we're told you can't examine him, you can't get an independent medical report, but when you have extrinsic facts which give reason to doubt that he is unable either to appear or to furnish information that you've asked, you cannot raise them because you're not impugning the medical report. Well, they can't have it both ways. If Mr. Karim wants to make himself available for our own independent psychiatric or other medical examination, we will do that. And we will arrange that an appropriate specialist dealing with whatever medical conditions he has raised, which range across a very wide spectrum, are investigated and a report is furnished. Finally, I want to emphasize one particular misconception. And it is this. Mr. Karim comes here asking for a postponement without making a postponement application. We have information that makes us concerned about the bona fides of his claim to a postponement application. We are giving him advance notice so that his postponement application can address those issues on which he will have to satisfy the Commission. He seems to proceed from an assumption that he can have a postponement if he wants one, and it's for the Commission to show that he shouldn't have a postponement. It works the other way around. He needs to satisfy the Commission. And in order to satisfy the Commission, he's going to have to address these concerns that we've raised. That's why we've raised it. And that's why we've raised them informally, and that's why we've raised them in advance of a postponement application. In relation to the timetable, we have suggested Friday because we have had a succession of witnesses this week who were scheduled who have not appeared and who are not appearing. So scheduling this postponement application on Friday will no longer interfere with evidence time that we have scheduled. We've had, in fact, all 5 days of scheduled evidence, originally scheduled evidence, or 4 of the 5 days of originally scheduled evidence this week fall away because of postponement applications. So this Friday is not going to interfere with scheduled evidence time. If we get to next Friday, we will interfere with scheduled evidence time. And the debates in relation to Mr. Karim's evidence and appearance and non-appearance have thus far taken up days of Commission hearing time, and we don't have days to waste. So we want it done this Friday because this Friday currently is a day which is sitting fallow. As far as the in-camera concerns raised by my learned friend go. If there are legitimate concerns in relation to privacy, we are happy to accommodate them, but whatever happens in that regard needs to be tailored very tightly so that any in-camera process is confined to that which is necessary to address the privacy concern. Those are our submissions, and we would ask that this postponement application be brought on a timetable where we can give the extra time to our learned friends. They can file their papers by close of business tomorrow. We will respond by 11 o'clock on Friday morning, and the postponement can be heard on Friday afternoon.
Chair, excuse me, Chair, may I seek, firstly, as a matter of protocol, may I seek an indulgence to address you on one point that I must respond to that was raised by my learned friend. It's this point about my client can't have it both ways, about the independent examination on one hand and then subpoena the doctor. You will remember in that general discussion we had the last time, it's not one or the other. My client placed on record that the power of independent examination is open to serious doubt. And you'll remember I explicitly said, I used the phrase, there are less intrusive means that are available to the Commission if there's a doubt about the medical evidence, and the subpoenaing of the doctor is one such option. So there is no inconsistency between what I have said to you today and what I have said to you previously, and that's as far as I'll take it. Thank you, Chair.
Thank you. On this, Mr. Oh, sorry.
Mr. Premier, I understood Mr. Chaskalson to simply be making the point that you are not correct to say this medical certificate has not, no doubt has been cast on it. And all he was saying was, we have said he should go for an independent examination. That's the only point I thought he was making.
Then please strike what I've just said from the record if I was incorrect in my understanding of what my learned friend said. I just wanted to make sure on the record that there's no ground to suggest an inconsistency. And that's as far as I'll take it. Through you, Chair, obviously. Thank you.
Thank you, Mr. Premier. I guess there's no need to respond, or is there, Mr. Chaskalson?
No, Chair.
Thank you. Just one aspect. I assume that the several issues you itemized are the sort of issues that would have to go to a ruling or the ruling. Or not? Remember, you itemized a few.
Yes, I've certainly itemized. I'm not suggesting they should go into an order, but if they aren't responded to if they aren't addressed in the postponement application, we will ask the Commission to draw its own inferences.
We proceed on the basis that Mr. Karim, through his legal representatives, has heard the issues that you itemized.
Just in fairness to Mr. Karim's legal representatives, maybe I should run through them again. And what we were asking for was the dates on which Mr. Karim has been admitted to hospital over the last 4 months.
Just, I see the paper is being sorted out, and I think when you started, they were not ready yet. Please, Mr. Chaskalson. Yeah.
The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which Mr. Karim has attended medical consultations over the last 4 months, his travel movements over that period, how he traveled to Cape Town in the last week, if indeed he or beforehand, if indeed he has traveled to Cape Town. And it seems that he has traveled to Cape Town because one of the medical reports speaks to hospitalization in Cape Town. Whether Mr. Karim has attended social engagements over the last 4 months, whether he has played a role in the management of his business over the last 4 months, and if not, who has been responsible for the management of his businesses.
And Chair, as a clarity, I think Mr. Chaskalson's extension of the travel arrangements covers Commissioner Kumalo's supplementation of the original list, so to speak.
And let me just clarify where it comes from. In his presentation, Mr. Chaskalson said they have information that he has been traveling from the northwest. So I know that there's no airport in the northwest, so unless he drove to Cape Town, I'm assuming he would have flown from either OR Tambo or the other airport. I can't remember what it's called for now. So that is relevant to me, because if you can give instructions to anybody to book flights for you, then you can give instructions to those who are running the business to provide the detail the Commission is looking for.
Yes, thank you. Thank you, Chair and Commissioner Khumalo.
Oh, just, yeah. Perhaps, before, I'll give you a chance, Mr. President.
I was saying thank you for the clarification and the amplification as to the travel arrangements, because my learned friend said travel arrangements broadly, but Commissioner Khumalo has a specific travel arrangement in mind that needs to then be dealt with. That's what I was saying thank you for. I'm indebted to Commissioner Baloy.
Thank you. And Mr. Shaskalsin, perhaps it's best for you to just give a piece of paper to your colleagues.
I'll do that immediately after the hearing.
Mr. Chaskalson, you have narrowed down his activities, business activities, to management. Can I suggest that it be in the business affairs and not narrow it down to management, because management could easily be interpreted as being purely operational. And what we would like to know is what has been his involvement, if any, in the affairs of his businesses. Thank you, Chair.
I'll do so, Commissioner.
There is the matter of detail around the exact timing about filing, for example. Let's leave you and Mr. Premier to discuss that detail and even the time when the application should be heard. But let me upfront say that the decision I make is for that postponement application to be heard this coming Friday. But the question of when exactly tomorrow the application should be filed, when the answering affidavit should be filed, and the exact time at which the application should be heard on Friday, may I ask Council to please discuss that. And once you have agreed, Mr. Premier is excused, and Mr. Shaskalsin can just bring that to our attention, say after lunch, and a ruling then gets made.
Thank you, Chair. We will do that.
Chair, may I please just ask a clarity, and I'm sorry to do this, but you'll remember on the last occasion when I argued for an in-camera application in front of you, part of my submissions was to say, well, the horse is already bolted, because in trying to justify the in-camera, we went to the details. I've already flagged the fact that there's going to be a request for in-camera. Obviously, if the Commission, through the evidence leaders, opposes that request, that's a different story. I'm just flagging now that come Friday, it's not just the postponement that might need to be determined. There would also need to be consideration of the in-camera and how it is going to be argued in front of you in a way that balances.
Yes. If in the light of what Mr. Shaskalsin said, which I thought was quite accommodative, if that will still be an issue, let's consider that if and when it arises.
Perfect. I'm indebted.
And Chair, can I suggest something else? That pending Friday, this Commission issues a ruling essentially stopping speculation about Mr. Karim's trying to contain speculation about Mr. Karim's medical condition pending Friday, because the issue is going to be, I don't know how to formulate it, but I do think that there is a risk that coming out of today's hearing, there may be wild speculation in the media. Can I speak to Mr. Premier about that, and when we come back to you with a timetable, we will do that. We will include a proposal in that regard, but it may be I don't know how we take that further.
On the last point you made, Mr. Shaskalsin, may I say, please make it part of the discussion, and let's see what comes out of that. We are subject to what Ms. Silo says. We are minded to take an early lunch and come back at 1:45. But of course, we will hear Mr. Shaskalsin first. If Mr. Premier will not be coming back for whatever issue he might still want to address. If there's agreement and there's a draft ruling, then Mr. Shaskalsin will come back and...
I'm indebted. That's very kind. Thank you.
Yes. I've just been overruled, and the suggestion is for us to come back at 2 p.m. We'll adjourn and resume at 2 p.m. Let's adjourn.